Hello students, welcome to my channel Learn Law with Professor Ashmi. Today I am going to begin video lecture series on banking law, one of the optional subjects from last semester, widely opted by students in LLB 3-year course as well as BBA LLB 5-year course. Though the syllabus for both the courses is quite different, some topic remains same and equally important. In upcoming 3 to 4 lectures, I am going to discuss about one important topic from where most of the situation-based problems are asked in exam. I have also uploaded a video on how to attempt situation-based problems in exam. You can go and watch the same. I am posting the link of the video in the description box. So let's begin with today's topic, banker-customer relationship. Today we are going to discuss different types of relationship that exist between banker and customer, how to identify them. In upcoming videos, we will also discuss banker's obligation to honor checks, banker's obligation to honor checks when garnishee order is received, maintain secrecy, banker's right to lien and set off, and others. So do subscribe to the channel and press the bell icon so that you do not miss any of the lectures. Coming to today's topic, banker-customer relationship. First we need to understand who is a customer. Basically a customer is a person who is having an account in a bank. Would be a general definition because customer term has not been defined in law. So person who is an account with the bank is considered to be a customer. In past, banking experts and legal judgments used to say that a customer is a person who would be qualified only if the period for which such account has been maintained with the bank. So duration theory was supposed to be followed, that for how much amount of time a person is holding an account with a bank would define he being a customer or not. This was also supported by Sir John Spaghet's view, which said that to constitute the customer there must be a recognizable habit of dealing in nature of regular banking business. So basically duration theory was one of the important things to qualify a person to be a customer. But later this mindset or this approach was changed by Kerala High Court's decision in Central Bank of India Limited versus Gopinathan Nair and others, AIR 1979. So what if I am opening an account with the bank today and tomorrow if I am facing any relationship issues, so would I not be a customer because the duration is not being maintained? That is, I have not been having an account with the bank for a certain period of time. So duration is not going to help me qualify whether I am customer or not. But a person who basically has a bank account in his name, who has deposited the amount with the bank for opening an account, then a banker is going to undertake some facilities to be provided as a banker. That is not necessary or it is not essential that account must be operated for a certain period of time. So even a single deposit in account is sufficient to qualify a person as a customer, because though he is right now only having one transaction of opening an account with the bank, it is expected that this customer is going to develop and continue the banking transactions or regular dealings with the bank. So basically this Kerala High Court view is that a customer would be a customer even if it is a single transaction or it would be a series of transactions which is over a period of time. In both the cases a person would be a customer. So let's see what are the essential requisites of being a customer of a bank. A person who does not deal with a banker in his essential functions, like see nowadays we do deal with different types of bank or different services, like having just demand draft or having your check in cash which is given by someone else. So in this case, are you going to be a customer? No. It would be a customer. A person would become a customer of a bank only when he is doing such functions which are essential for the banking business. What are the essential functions of banking? Accepting deposits and lending money. So when a person is dealing with the bank in regard to this essential functions of a banker, he would be a customer. But if he is availing any of the other services rendered by a bank, like as I said, remitting money through bank draft or encashing a check received by him, in such cases he won't qualify as a customer. So to constitute a customer, following essential requisites must be fulfilled. First is to have a bank account, either savings or currents or fixed deposit, and must be open in his name by making a necessary deposit of money, and dealing must be between the banker and customer must be of the nature of a banking business, that is either accepting of deposit or lending of money. Then only he would qualify as a customer. Who can become a customer? Natural person of course can become a customer, and also a legal entity. So legal entity can be a firm, can be a company, a joint stock company, a society, any other legal entity can be a customer of a bank. As per the explanation provided to section 45 of Banking Regulation Act, it is clarified that any government department or corporation which is incorporated by or under law are also customers of a bank. Now, after understanding who is a customer of a bank, let us understand the banker-customer relationship that exists between banker and customer. Now, in contractual obligations, you already know there are different types of relationship like a debtor, creditor, agent, trustee, and all. So, basically, a primary relationship between a banker and customer is of debtor and creditor, or creditor and debtor. Now, who is a debtor? A person who owes money to someone else. Who is a creditor? A person who has lent money to someone else. So you understand who is a debtor, who is a creditor. So in different types of relationship, bank can either be a debtor, bank can either be a creditor. Similarly, a customer can be a debtor and customer can be a creditor. Others are of course agent, trustee, we will discuss in latter part, which are quite easy to understand, right? So talking about debtor-creditor or creditor-debtor relationship, always remember that when I am depositing my money in a bank, so this is lent by a customer to a bank, isn't it? So when I deposit, a customer is depositing a money in the bank, this money is lent by the customer to a bank, and banker is going to use it further for lending, right? So when a deposit of money is made by a customer, here customer would be a creditor and bank would be a debtor. Why not trustee? Why don't you feel that bank won't be a trustee? Reason here being, a trustee would be a person to whom I deposit my something as a safe custody maybe, and that something, that valued thing is given to me in same form. So when I deposit my money in the bank, suppose today I have deposited rupees 5,000 in rupees 500 denomination. See, 500 denomination, I deposited 5,000 money in a bank. After few days when I go to withdraw that money, bank is giving me rupees 5,000 but denomination is rupees 100. So here you understand that I am receiving my money back, but it is not in the same format which I had deposited with the bank. It is not the same serial number of that currency, or it is not the same denomination of the currency which I am going to get back. In case of safe custody, that is in case of agent or trustee relationship, you will see that when you are giving something to someone as a trustee, the same thing would come back to you. Like in safe deposit lockers, when you keep something, that same thing you are going to get. Here nothing, the bank doesn't have any control over it. So basically the deposit with the bank would be a debtor-creditor relationship. It would never be a trustee relationship. It would be a trustee relationship in some cases. We will discuss it in the latter part. Let not confuse here. So basically when I am depositing my money with the bank, I am creditor to the bank and banker is the debtor, and I am availing a loan or credit facility from the bank. So suppose bank is giving me a loan of rupees 5,000. Here I become the debtor of the bank and bank is my creditor. Only difference here is when I am depositing my money with the bank and I am becoming a creditor of the bank, I am not getting any charge over the assets of that banking company. So here I am becoming the unsecured creditor of the bank. But when bank is giving you a loan or credit facility, usually it is upon the assets or a charge created over my assets. So security is something which is a tangible asset. Therefore, bank is a secured creditor. While when I deposit my money in a bank, or a customer is depositing his money in a bank, customer is always an unsecured creditor. Of course, there is an deposit insurance and credit guarantee corporation which undertakes to insure deposits up to specified amount. So the element of risk of depositor is minimized, but still customer who is depositing money in a bank is going to remain an unsecured creditor of the bank, and the bank which has given you a secured loan is always being a secured creditor. So simple to understand. After after discussing this debtor-creditor relationship in detail, let me tell you that general debtor-creditor relationship in commercial debts differs to quite extent from the relationship which bank and customer has. When bank is a creditor and customer is a customer is a creditor and bank is a debtor, and in case of commercial debt, what the debtor-creditor relationship would be, these are totally different. How? First is creditor must demand payment. In regular ordinary commercial debt, you will see that debtor is going to pay the amount on specified date or earlier, right? So there need not be any demand which has to be made by the creditor again for that amount. It is the obligation of the debtor to pay on a particular date. But in case of debtor, when bank is a debtor, it is not required to repay amount on its own accord. It would repay that amount only when the creditor is demanding payment either by way of check or any other ordinary manner. So it is essential that creditor is going, that is customer or depositor is going to make a demand for payment of deposit in proper manner. This is a difference between a banker and an ordinary debtor. So this is the first difference. Second is proper place and time of demand. Demand by creditor must be made at proper place and in time. So suppose if now I am going to a bank before banking hours or after banking hours and I am asking for money, though I am a creditor of a bank, I won't be given that money because that demand is not made at proper time. With respect to proper place, suppose I am having an account with a particular branch A and I am going to some branch C of the same bank, then it won't be a proper place. Demand has to be made with a particular branch only. Now with the core banking solutions, so branches are interconnected through computers and the facility of encashment through other branches is possible, but that won't be amounting to proper place. So proper place and time of demand is necessary. Though I am a creditor of a bank, I cannot go on some Sunday or a public holiday and go to a bank and ask that I am a creditor of a bank and I need my money back. So this is another difference between a regular debtor-creditor relationship and the banker as a debtor. Third is demand must be made in proper manner. So according to the statutory definition of banking, deposits are withdrawable by check, draft or otherwise. It means that demand for refund of money which is deposited should be made by check or as order or any other common usage amongst the bankers. So if I go to a bank and I demand verbally, I want my 5,000 rupees, or by a telephonic message, I say that I want my money back. Whatever I have money which is deposited, because I am creditor, I can ask for money in that manner. No, demand has to be made in proper manner. This is what differentiates a bank from another debtors, regular debtors, right? So this is moving forward. Let us discuss some other relationship, banker as a trustee or banker as an agent. Banker as a trustee means that generally who is a trustee, who is holding money or assets and performs certain functions for benefit of some other person who is called a beneficiary. So if I am suppose depositing securities or other valuables with the banker for safe custody, then bank is acting as a trustee of his customer and customer continues to be owner of those valuable which is deposited with the bank. Now there can be a question in your mind, banker can act as a debtor also, banker can act as a trustee also. How are you going to differentiate? So differentiation would be according to the circumstances of the case, which means that suppose I am depositing money with the bank in regular course of banking business. I am having extra 5,000 rupees, I am going to the bank, I am depositing it with the bank. Here no specific instructions are given to the bank to use that money in particular way. Banker would be a debtor and I would be a creditor. But if I am going to the bank, suppose I am sending a check for collection from another banker. Here banker is going to act as a trustee till the check amount is realized. Once the check is credited, that amount is credited, then bank is going to become a debtor. Suppose I am depositing money with the bank for a specific purpose. Here it would be actually as per my instructions that money, suppose I am depositing money with the bank for payment of some insurance claim or some any other requirement. Here bank would be acting as a trustee because that money has to be, so specific instructions are given to the bank that you have to use this money for this particular transaction only. Here bank would be a trustee. So generally the relationship between the banker and his customer as a trustee and beneficiary would depend upon the specific instructions given by the customer to the bank regarding the purpose of use of that money or documents which are entrusted to the bank. So if customer is instructing his bank to purchase certain securities out of his deposit and bank fails to do so, the amount which is with the bank, here bank would remain as a debtor, because bank failed to use that money as per the specific instructions. That is the reason now bank would be again a debtor. So how are you going to differentiate between whether banker is a trustee or banker is a debtor? It would be as per the instructions. So if there are any specific instructions attached to that money, then it would be either bank would be a trustee or agent. But if there are no specific instruction attached, if it is general deposit of money, bank would be a debtor. And banker as agent, easy to understand. Banker is going to act as an agent for his customer for myriad of functions, agency functions, like buying or selling of his securities on behalf of the customer, collecting the checks on behalf of the customer, making payments of various dues like insurance premium, etc. And range of such agency functions has become wider in today's day, and because banks are now rendering myriads of services, large number of agency services. For example, like they are of diverse nature. For example, like some banks have established the tax service departments so that tax problems of customers are solved. So it is an additional agency service. It is not a basic banking service, right? So these are the other relationship, the most important being the debtor creditor or creditor debtor relationship with the bank. In upcoming videos, we are going to discuss the banker's obligation to maintain secrecy, when his banker can divulge from maintaining the secrecy or divulge with the personal information of the customer, under what circumstances, what is the banker's obligation to honor check, and when banker can deny from honoring the checks, what would happen to the garnishee order, and what would be the banker's obligation in that regard, what are the banker's right to lien and set off. All these things, very interesting part, we are going to discuss in our upcoming videos. Also, these are going to help you in solving your situation based problems. So do stay tuned, subscribe to the channel so you get the updates, regular updates with respect to these videos. Till then, keep studying. Bye. Thank you.